is Mark Caddle. I'm a partner in the Trademark Group in our London office, and today we're going to speak to you about Brexit and its impact on IP rights in the UK primarily and in the European Union. But first of all, a quick point on patents. Today we are not going to speak too much about patent protection in the UK and Europe because Brexit doesn't have any impact on European patents. The European Patent Convention is not tied to the European Union. Therefore, the UK's exit from the European Union does not affect the European patent system. So we continue as a firm to prosecute European patents under the European Patent Convention, and we also handle direct national patent filings in the UK, France, and Germany. So if you had any interest in finding out about how Brexit impacts patents, hopefully that short, succinct summary will put your mind at rest that nothing has changed and the impacts are most felt in the trademark and design sphere. So today we'll tell you how Brexit has affected EU trademarks and designs and what you should be doing now or what you should have done already to ensure that your clients' trademark and design rights continue to be covered in the UK and in the European Union following Brexit. And we'll give you some strategic advice on what to think about in the future when approaching protection of trademarks and designs in the UK and the European Union, as well as flagging to you the key differences between EU and UK trademarks and designs just for your reference, because the systems are a little bit different. So first of all, as you probably know and why you're here today, the UK is no longer a member of the European Union as of the 1st of January this year, 2021. So on the slide here, we have a reminder of the EU member states in blue. And as you'll see, the United Kingdom now appears in grey as a non-member state of the European Union. So going forward, what this means is that any new EU trademark applications or any EU design applications that are filed will not protect the UK. That applies today. It has done since the start of this year. And separate UK applications are now required to cover the United Kingdom. So previously, as you probably are aware, the European Union offered a single unitary right for both trademarks and designs that would cover all of its member states. And at that time, the UK being part of the European Union system, a single EU application would cover the 27 member states that remain, plus the UK, so 28 states in total. But now that isn't the case, and you're well advised to think of the United Kingdom and the European Union as being completely separate from a trademark and design perspective, and also just generally as well, to be fair. So that's a message that will endure throughout this presentation and a point that I'll touch upon a few times as we go forward. So we'll cover why this is important and what you need to be aware of and what you need to do. One of the things that should be mentioned now is that, as I said, dual filing, as we like to call it, two separate applications, one in the UK and one in the EU, are now required to get you the protection that you could have received before the 31st of December 2020. And one of the things that has happened at the UK Trademark Office is that it has amended its address for service rules. So as of the start of this year, any new applications that are made to the UK Trademark Office must be via a representative based in the UK, and the UK IPO will no longer accept any addresses for service in the EEA. So previously, for example, a French attorney would have been able to file a trademark application directly at the UK IPO and prosecute that like a UK attorney would have been able to do. But that practice has now changed. So for any new procedures that are lodged at the UK IPO from the start of this year, be it new trademark application filings, new design filings, any oppositions, for example, those will need to be handled via a UK address for service. So just something to bear in mind that has changed, and I thought I'd mention that at the outset because a lot of what we're going to speak about today relates to filing new applications in the UK. And previously it may have been that your European Union applications were handled by a firm not in the UK. And it's just to make the point that there would need to be a change in your decision-making process to have UK covered in the future. So there's two different scenarios that I will speak about today. The first of which is where at the 31st of December 2020, your trademark or design applications in the European Union are fully registered and published. So this scenario applies to any trademarks and designs that were registered as at the 31st of December 2020. So this scenario is quite simple, quite easy to follow, I hope. What has happened as of the 1st of January this year is that an automatic split has occurred where the UK IPO has created automatically at no cost, and this has already happened. All these registrations are listed on the UK IPO registration database. You may already have taken these details onto your dockets to manage for your clients, for example. But what has happened is we have now the EU registration, trademark or design registration, continues as it is for the other 27 member states of the European Union, but a new UK registration has come into being as of the 1st of January this year. So you automatically have separate and independent UK and EU registrations on the same basis, identical details, filing date, priority date, goods and services, owner or design representation, as would have applied for the EU registration that is now in effect in the UK. So these new UK registrations can be enforced, abandoned, licensed, renewed separately to the EU registration. So that EU registration will continue in the EU so long as it's renewed and kept enforced, then you'll have two separate registrations instead of one. And as I said at the outset, and Tania mentioned in her introduction, we can provide assistance at both the UK IPO and the EU IPO, so we can handle the new clone registrations that have come into being in the UK, and continue to monitor renewals and handle registration at the EU IPO. So that's something to bear in mind. And one of the other things that is worthwhile mentioning, which I think is on the next slide, is that these UK registrations have come into being automatically. No decisions have been required by trademark or design proprietors. They just now exist. There was no fees to pay, so it was easy for that to happen. But you may, or your clients may, wish to not receive UK registrations on the same basis as their European Union parents, if we're going to call them that. So there is an option at any time at the UK IPO that you can opt out of that automatic UK registration cloning or comparable registration process that outlined in the first scenario. So if you do not want the UK registration, you can advise the UK IPO and it will be removed from their records, and that can happen at any time. So as I said, there's no action required for registered rights. New trademark and design registrations have already been created in the UK at no cost, and it's important for you to understand the details of those new registrations because they will require their own management, their own renewal. So it's important to docket the details of the newly created UK registrations. Needless to say, we can help with providing any information that you require from the UK IPO or the EU IPO to satisfy your records requirements and to pass that information to your clients. One thing I should mention, it's more of an administrative point, is that the UK IPO has not issued new certificates of registration for the newly cloned comparable UK design and trademark registrations that have come into being. So don't expect to receive a new certificate telling you that the UK registration has come into being. It's simply a case that the UK IPO took onto its records all of the existing EU registrations at the 31st of December, and their records have been updated to show that those marks and designs are now enforceable in the UK. And we have updated our records to include those newly created UK rights. So if you have any registrations which we manage on your client's behalf, we will be able to share with you, if we haven't already, those particular details so as to avoid losing sight or missing out on understanding the extent of the newly created UK portfolio. One thing that's tied to that is the new numbering system, which has been implemented by the UK IPO. And this exists to remedy the lack of registration certificate, perhaps, but also to identify to users of the UK IPO records that new comparable UK trademarks and designs came into being via this cloning process that I described to you. So what to look out for, as detailed on the slide here, is that for any existing EU trademark registrations that were in place at the end of last year, which have been cloned into the UK system, those marks will appear on the UK register with the last 8 numbers of the parent EU trademark, but with the prefix UK 009. So if you ever see UK 009, you know that that was a Brexit UK registration, if I can call it that, a comparable registration that came into being following the rules in place to have those marks come across to the UK register. And similarly for EU designations of international trademark registrations, the prefix will be UK 008, and it will contain the last 8 numbers of the existing international registration. So again, the same logic applies. If ever you are reviewing UK trademark records, may it be via search, for example, when you see UK 008, then you will know that that came into being as a result of the comparable registration process that we're discussing today. Similarly, on designs, the number that applies is 9 for existing registered community designs that are cloned into the UK. So the existing 13-digit registered community design number will appear with a 9 at the front of it. And for EU designations of international design registrations, should your clients have any of those in their portfolios, and know that New Zealand and Australia are not members of the Hague International Design System, but those particular designs will be prefixed with the digit 8. So again, these points are more administrative, but these are the sort of things that we are seeing causing some issues for docketing purposes and just having the right details to share with clients. And you might appreciate that over the last few months, we have had a lot of interest around ensuring that portfolios are correctly updated and managed properly going forward, particularly with the impact on having to renew these new UK design and trademark registrations separately. What we don't want to happen is there to be any loss of rights because the newly created UK design registrations haven't been captured properly. So that's the scenario on registrations that were in place at the end of last year at the EU IPO. But what about pending applications? So that is a completely different scenario, what we've called scenario 2. And this applies to pending EU trademark and design applications at the EU IPO as of the 31st of December 2020. So, for example, you may have filed on your client's behalf an EU trademark or design application in 2020 at some point, but at the end of the year, it was still pending. It hadn't been fully published and it wasn't registered at that time. So the scenario here is completely different to the one that I mentioned previously. There is no automatic action here. This does require action from your clients or from you to put the UK protection into place. There isn't an automatic UK right that is created here. So for any pending EU applications at that time, they will just continue for the other EU member states, but not the UK. But, and this is the important part to bear in mind, if you are interested in ensuring that the UK is covered, then you will have until the 30th of September this year, 2021, to file an application for an equivalent UK trademark or design which would replicate the effects of the existing EU application into the UK. So what that means is that the filing date or the priority date, or both, those will be taken onto the UK records. The same mark or design, the same goods and services for trademark applications, the same owner, everything will be the same, so long as you make the application in the UK before the 30th of September. So this is essentially a refiling of the EU trademark application into the UK to preserve the rights of the EU application. If that 30th of September deadline isn't met, of course, it's still possible to file a trademark application in the UK. It just won't benefit from the earlier EU dates, which is important. The other thing which is different is that this will incur cost because the filing fees will be required at the UK IPO for both trademarks and designs. So as I said before, for registrations, everything has happened automatically without any decision making on behalf of trademark and design proprietors. But for pending applications at the end of last year, this does require a conscious decision. It does require payment to the UK IPO. And with the general flavour of today's webinar, we can handle both the EU and the UK parts to these processes. So we can file the comparable UK applications while seeing the EU applications to their registration. So nothing really changes in that respect as to how we can help you. As we mentioned at the start, we are a European firm with offices in the UK and in the European Union, and therefore nothing really changes for us, and we can act at both the UK and EU IPOs. So a couple of things to bear in mind. As I said, the September 30 deadline is important, so please, if you do have any applications which were pending at the EU IPO at the end of last year, make a note of this deadline and take instructions on whether or not new UK applications are required. As I said, we can handle the UK comparables on your behalf if needed. And all we really need to know is the details of the EU applications. But in some instances, we've been handling those EU applications anyway, and it's a fairly straightforward process. But as I said, the UK IPO filing fees apply, and that is simply unavoidable. And the other thing that I mentioned at the outset, again, that the refiled comparable UK applications do require an address for service in the UK, slight change to previous times. And an interesting point which I should mention is that and you may be familiar with the Madrid system, a lot of the interaction that we have with Australia and New Zealand is via the Madrid Protocol, both applications that we file on behalf of our clients and the work that we do for clients in that part of the world, is that for EU designations of international registrations, it won't be that, and this applies to both the new application that is required in the UK or the automatically created comparable registration. Those will be national UK trademark or design rights. They won't be an additional designation in the UK of the international registration system. So what that means is that the UK registration will need its own management separately. They will require its own renewal separate to the renewal of the international registration, but it does continue to take the filing dates and any priority dates from the EU designation in the international registration. So that's one thing to bear in mind, that it isn't that a new UK designation is added in to the international registration. it's that a new national UK registration is created. But as I said, we can continue to handle those new rights in the UK and in the existing the existing EU designations as well, and we can directly file in the UK and the EU, and also handle any provisional refusals of UK or EU designations that may crop up in this part of the world as well, for any international registrations that you're coordinating from Australia or New Zealand. But for pending applications, that deadline is the one which I think from today's session is important to take away. It may be that you've been reviewing the EU designs or trademarks that you handle to see whether or not this will apply, but it's certainly worth bearing in mind. And we've had a lot of traction on filing new applications already to meet this deadline, and I suspect that will continue throughout the rest of this year. So we've got a few slides on particular aspects of the trademark and design systems that have changed as a result of Brexit. Again, as I said at the start, the thing to bear in mind is that the UK and European Union have essentially parted ways at the start of this year, and a lot of the benefits of having European Union law directly applying in the UK no longer exist, and there has to be two decisions to be made as opposed to the for the UK, as opposed to just one that applies to the European Union as a whole, which would include the UK. Hopefully you follow that logic. And the first of these is customs notices, which you may or may not be familiar with, but essentially are a way in which you can protect against any infringement of IP rights for imports or exports into or out of the UK and the European Union. And essentially you will advise the customs authorities in the UK or in the European Union to monitor the incoming and outgoing traffic from the UK or EU to determine whether any infringing products are being shipped into or out of the territories. And this is quite a good way to be flagged of any counterfeit products, and the process tends to be that your representative in the UK or the EU will be advised that customs have seized a batch of products that appear to be counterfeit, and then you can advise your client of it, confirm or deny whether they are genuine products of your client, and if they are counterfeit, then the standard remedy would be to have them destroyed so they don't enter the UK or the EU. There's a very short summary of the application of the customs notices here. But the important thing to bear in mind is that the European Union customs notice will no longer apply in the UK. So it would be prudent to apply separately for a UK customs notice, or what we tend to call an application for action, separately, to ensure that the UK and the EU is protected. So if your clients were relying on, up until the end of last year, an EU customs notice, and they haven't sought to reapply for that in the UK, it would be a good idea to raise that question with them to find out if the UK is still a market of interest to them. The other thing to bear in mind is any recordals that have been made against EU registrations, or any pending assignments that were pending at the end of last year. It's important to record any licenses or security interests against the newly created UK registrations by January 1, 2022. If that doesn't happen, then they won't be recorded against the UK comparable right in the same way as they were against the EU parent. And one thing to bear in mind is this is a sort of victim of timelines of the EU IPO. You may have cases where you applied to record a transfer of ownership at the EU IPO towards the end of 2020, and at the start of the year that transfer of ownership was pending, so the EU IPO hadn't processed the request. They normally take about 4 to 6 weeks to do that, so anything from December onwards probably would still have been pending at the end of the year. Now, if that wasn't finalised as at the 1st of January, the new UK comparable registration will have come into being with the old owner's details, not the newly assigned owner's details, which would have been the effect of the EU assignment. So it may be that the EU registration, once the assignment recorder was concluded, that will stand in the new name, but the UK registration will be in the old name. So you then have to take action at the UK IPO to remedy the fact that the assignment wasn't recorded in time. So if you have that particular situation, which I do suspect is quite rare, then it would be worth making sure that the UK IPO has the same ownership details in place and to have that assignment re-recorded at the UK IPO. I've already spoken a bit about renewals, but it's worth mentioning them in some more detail. As I said, for the new UK registrations that have come into being, they require their own renewal. So their renewal deadlines need to be managed by you and docketed by you. Clients need to be aware of the fact that this is required. And of course, one of the things, maybe perhaps a downside to this, is that additional fees will be required to keep the UK rights in place. And needless to say, if the UK rights are not renewed, they will be lost. So it's important that if your clients do have an interest in the UK market, to keep on top of the new comparable renewal deadlines. And one particular point I should mention is, and this is primarily due to experience and feedback from clients on this particular point and a quirk of the system, as you might be aware, renewals can be instructed up to 6 months early, which technically could have meant that you were able to renew an EU registration that fell due in 2021 before the UK left the European Union. So to take an example, say you renewed an EU trademark registration at the EU IPO on the 1st of December for a renewal that was due in 2021 on the 1st of February. The 1st of February renewal deadline will have been satisfied for the EU, and that will be moved on for 10 years. The EU renewal will be in effect, but the UK IPO won't honour that early renewal and will require renewal to be made in the UK by that 1st of February deadline. So if you had a situation where you thought that you'd renewed an EU registration early, that will not apply to the comparable UK registration if that renewal date was after January 1, 2021. So if there was any EU renewal dates that you actioned which were falling due after the 1st of January this year, separate renewal will be required in the UK to keep the UK comparable registration in place. So if that situation applies and you're aware of it, or if you want to find out more, it would be worth looking into that to ensure that the UK mark doesn't go without renewal. Because logically, if you were instructed to renew the EU registration before the end of the year, at that time it covered the UK, although we knew Brexit was coming and it wouldn't, then it may be that the intention was to cover the UK. So it would be important to make sure that does happen. And a couple of points on dates, which I take are slightly confusing perhaps, but just something to get right and straight in your mind is that for new comparable UK applications that are filed for any pending applications at the end of last year, the renewal date will be based on the filing date at the UK IPO and not the filing date at the EU IPO. So for trademarks, this means that, as I said, the material details are the same as the EU pending application. You know, the goods and services you do benefit from the earlier filing date and priority date so far as the rights are effective from now. But for renewal, that is going to be based in the UK from the date that the comparable UK application is filed in the UK. So if you have a pending application at the EU IPO on the 31st December and today you make a new UK application, the UK application will be due for renewal 10 years from today. This is different from designs, which makes it slightly more complex, where the renewal date will be the filing date at the EU IPO. So again, these are just important things to get straight for your records management to ensure that there's nothing missed on renewal. And finally, for new comparable UK registrations from subsequent EU designations, the renewal date in the UK is based on the filing date of the subsequent EU designation and not the filing date of the international registration. So for any cases where you have the EU subsequently designated, it's the date on which that request for subsequent designation was made that will form the renewal date of the comparable UK registration that came into place. Now, there's quite a lot of dates to manage here and a lot of timelines to be aware of. And one thing that if this is something that you need to review, if you were to share with us, the EU trademarks or trademarks and designs that you handle, we can give this information back to you insofar as new numbers, new renewal dates, so you're aware of it, a sort of cleanse of the data essentially to make sure that there's nothing that's going to be missed. Just a couple of points on opposition and cancellation matters, so any contentious proceedings that were in place at the EU IPO and at the UK IPO as of the end of last year. So anything that was pending at the EU IPO as of the 31st of December, which was based on UK rights. So previously you could oppose, for example, an EU trademark application based on the fact that you were the owner of an earlier UK trademark registration. So there will be oppositions that have fallen victim to this particular rule. Any oppositions which are based, or cancellation invalidation proceedings which are based solely on UK rights, those have been dismissed. And we've had cases already where the UK IPO has written to us to say this was only based on a UK right, therefore the case has been dismissed. So essentially the EU IPO has closed the door to any of these cases reaching their conclusion because they no longer acknowledge UK rights as being earlier in time and a basis for these opposition and validation proceedings. One thing to bear in mind, though, is that if you have any pending oppositions against EU applications, which could be cloned into the UK using the timeline, the 30th September 2021 timeline and mechanisms that I described, you will want to make sure, if your client so wishes, to oppose the UK comparable application that comes into place. So perhaps the easy way to manage this is to understand any oppositions that you have in place against pending applications in the EU, to monitor for any UK comparable applications coming into being, and if needed, to oppose them as well. And if you're relying on an EU registration, for example, at the EU IPO, that will have been cloned into the UK carrying the earlier date, so you can just replicate the proceedings in the UK, but that will require action and some careful monitoring. So it's worthwhile understanding the extent to which you have pending oppositions at the EU IPO. And any cancellation decisions that are issued by the EU IPO against an EU trademark registration are going to be honoured by the UK IPO. So for example, if there's a non-use cancellation action that's pending against an EU registration which is ultimately successful, the UK comparable registration will not continue in effect. So if you have any cases like that, it's worth bearing in mind the impact of those. And there isn't a need to launch a separate case, although again, there's a slight quirk in the system that if it is an EU designation that is the subject of the cancellation action, that will require a new action in the UK against the comparable UK registration. So again, this is a matter of just sort of cleansing your records to find out if these particular scenarios apply and taking action where needed. One thing to bear in mind, though, is if, for example, there's an invalidation action against an EU trademark registration and it's based on an earlier right from, say, France, where a French registration has been used to challenge the EU registration, because French registrations don't apply to the UK, those decisions won't affect the UK, and the UK trademark will continue irrespective of how the outcome is at the EU IPO, because those grounds would not be applicable. And one thing to bear in mind as well is that an EU representative is required to continue the proceedings at the EU IPO. But as I've said, we can do that at the EU IPO and at the UK IPO. It's just that UK practitioners without a European presence would not be able to continue those proceedings that are pending at the end of last year. Another point to bear in mind on the flip side to this is that the UK IPO, the actions which are based on EU registered rights, so if you have an opposition in the UK which is based on EU registration, that will simply continue. The numbers that we spoke about before will be updated to reflect the fact that the opposition is now on the basis of a UK comparable registration. So that's certainly something to just be mindful of, that those cases won't be dismissed, and they will continue. But if there's any of this which is unclear, or you have cases where you're not sure what the impact will be sure to let us know, and we can provide a steer for both the EU IPO and the UK IPO. One final summary, as it were, of the EU trademark opposition proceedings and the UK opposition proceedings. The systems are slightly different, and it's just something to bear in mind, particularly if you've only ever really interacted with one of the systems and not the other. And some of this might be familiar to you as well, just based on the practice and where you are. But first of all, for the UK IPO, we are quite big in the UK on advocacy, so turning up and having your day in court and presenting your case orally. That's quite favoured in the UK and happens quite a lot in the contentious setting. Whereas at the EU IPO, as you may be familiar, everything tends to be done on paper, and there is no real opportunity to turn up at the EU IPO and present your case. So that's just one thing to bear in mind insofar as the differences are concerned on hearings. The opposition deadlines in the UK is 2 months. That can be extended automatically to 3 months. At the EU IPO, it's 3 months, and that is not extendable. So just to bear that in mind if you ever have the need to look into oppositions in either jurisdiction. On evidence, we're quite an evidence heavy country in the UK, and we like things done via witness statements. So where we have someone with, so say for example, it's a cancellation action on non-use, someone from within the trademark proprietor's business will provide a witness statement to explain why the trademark's been used. They'll sign a statement of truth, and it's all quite formal in that sense. Whereas at the EU IPO, you can just present evidence without witness statement, and that's considered whether or not it is signed, sealed and delivered by someone senior within the trademark owner's business. There's a fast track opposition proceeding in the UK. If the trademark that are being relied on are more than 5 years old, then you have to provide your proof of use evidence up front. Just one thing to bear in mind. The EU IPO, there's no equivalent fast track. It's just one standard set. In the UK, it's easier to rely on unregistered trademark rights, and I think you'd probably be aware of this concept insofar as it applies in Australia and New Zealand as well, that we are quite favourable to rights under passing off, so trademark rights that are acquired through use. Whereas at the EU IPO, there is the ability to rely on unregistered rights, but you are tied to the particular laws of the EU member state in which use has occurred. So if you're a heavy user in Poland, for example, but Polish law doesn't favour unregistered rights, it's going to be a lot harder to enforce those unregistered rights at the EU IPO. Just one thing to bear in mind if you are looking to carry on with actions with unregistered rights rather than registered rights. And one final thing on the records accessibility, it's not a major point, but I found it quite interesting that at the UK IPO, our records system is quite limited in information that's there. So you can see a history of application filing details that are there, and if anyone has lodged an opposition, but that's really about it. And I think at the EU IPO, the system is far more penetrable. There is a document management system tied into the records where you can access and see some of the documents that apply to the cases. So it's very transparent, and a lot of information is held there. And I think having had cause to review the Australian and New Zealand IPO databases from time to time, I think they are probably more sophisticated than the UK system, but not as sophisticated is the EU system. So if you're ever navigating the registries in the UK and the EU, you'll have more joy perhaps at getting information out of the EU system than the UK. But as I said, it's a fairly minor point, but just something to bear in mind. I'm going to hand you back over to Tania now to speak about the UK application process.
Thank you, Mark. So yes, I'm going to have a look at the UK trademark application forms as well as the design application forms, and Simone is going to look at the EU equivalents. So the UK trademark application form probably isn't massively dissimilar to yours. You'll see on this one the fee of official fee of £200. It's actually £170 though if you file online, and there are additional class fees of £50 per class. And we at our firm don't charge any additional service charge on additional to that £50. You have to include the country of corporation, as you can see at the bottom, as well as all relevant details. And then we have a similar system to yourselves in the sense that we can file a series of marks, only a maximum of 6 now. And it means that if particularly for a logo, you could include different color versions. You do get 2 for the price of 1 in the sense that there's no extra fee for that second one, but you will pay extra for the 3rd, 4th, 5th and 6th of £50 per mark. Again, we don't add any service charge additional to that, but it's quite a useful thing to use. Obviously under the international system, you can't have a series, so you'll have to choose the black and white version. On the actual form, you then, as Mark was talking about the comparable applications to be filed before the end of September, you need to fill in details whether it's a comparable application based on an EU application, national application, or whether it's based on the EU designation under the international system. So you tick the relevant box there. And then underneath, there might have been an earlier priority claim. Again, you're going to retain that earlier priority date. So we're going to fill in details there. And then subsequently, we're going to put in the full details of whether it's an EU national application, which was earlier, or whether it was an earlier EU designation under the international system. Also, different to the EU system, the applicant must state that it has a bona fide intention to use the trademark, and it can be challenged if for whatever reason, for example, the applicant is filing in classes in which it would never be involved, particular goods or services, then quite clearly it didn't have a bona fide intention to use that trademark. And I'm going to hand you over to Simone, who's going to look at the EU trademark one.
Thanks, Tania. Yeah, you can see on the right-hand side part of the EU trademark filing form. And if you want to claim priority of an early application, you have to add the country of the first filing. So in this instance, Australia. And you also have to add the filing date of the earlier application. You have also to provide a priority certificate, and you can do that within a deadline of 3 months after filing the EU trademark application. There are 2 languages you have to select. So the first language is English for the correspondence, and the second language is for possible opposition matters. And as I'm based in the Munich office, we would usually choose German. Yeah, you can apply for a European individual mark, a EU collective mark, or a EU certification mark. If you want to protect a 3-dimensional shape, you can do that also with filing a European trademark application. Here you can see some further trademark types. So you can, for instance, apply for a sound mark or a motion mark. If you want a national search report from a national country like Germany, for instance, you can request for that, but you have to pay an additional fee, and this is optional. Or you can request for a European search report. This is also optional and free of charge. And I'm going to hand back to Tania, who's talking about designs now.
Thank you, Simone. So yes, just to give you a bit of contrast between the UK and the EU design system. So we do have a system of disclaimers which are available to limit the protection if you want to limit it down to particular features or aspects of a design, whereas the EU IPO doesn't have that system. We are much more flexible in the UK. You can have a multiple application, so lots of designs within one application, which makes it a lot more cost effective. And they can be across different Locarno classes. As you know, it's different for designs, you use Locarno classes, whereas an EU IPO, they have to be for the same Locarno class. For example, it may be one of your fashion clients and you want to protect the entire kind of range of clothing, as well as the logos. That would be possible in the UK, but under the EU IPO, there'd be a split between, say, the logo and the different items of clothing. Deferment, we have a shorter period of deferment of publication, so you can defer it up to 12 months in the UK. EU IPO is much more generous with up to 30 months. And then the renewal fees, again, are calculated differently. In the EU UK IPO, they're due on the anniversary of the registration date, whereas the EU IPO, they're due at the end of the calendar month in which the anniversary falls. The grace period is the same. You have a 6 months grace period for late payment of renewal fees. We're more generous on representations. You can have up to 12 representations, 12 different views or aspects of the design, whereas at the EU IPO, there are only 7. So under the UK system, each design within that one multiple application will get a different number. And there's no publication fee if you want it to be published immediately, if you don't want to take advantage of deferment. It usually takes about 2 to 6 weeks from filing, usually about 2 to 3. And publication registration can be deferred, as I said, up to 12 months from the filing date. So you do need to put in a title for your design, but any form of description is just optional. It can help to explain what the design is and the scope of protection sought, but as it's optional, usually we advise not to include that. And as I mentioned before, you can have a disclaimer using either visual or written disclaimers. So if it's a visual disclaimer, then you should have a corresponding statement, which again, it isn't essential, but it probably makes it easier to understand what kind of disclaimer is sought. So in this one, as you can see, features shown in broken lines are excluded from protection. So as I said before, you can include up to 12 different views, 12 representations, and these representations can be provided in different formats. And we're very flexible, whether it's UK or EU actually, that it can include photographs, line drawings, CAD images, 3D models, etc. Now, one thing to bear in mind is if you try to include representations which are not in the same format, one maybe a photograph, the other one a line drawing, then that's going to count as 2 separate designs. They can still be kept within the same application, but they will be deemed to be 2 separate designs, and you'll need to separate them out. So now I'm going to hand you back to Simone on the EU.
Thank you, Tania. So yeah, as Tania mentioned, the number of designs in a multiple application is unlimited. You can protect 7 views. You can add even more views, but they will not be protected. You can either search for your Locarno classification or you can enter your own terms. It is possible to delay the publication of your application for a period up to 30 months. You can add a description, but this is not mandatory and is also not examined, and the description can contain a maximum of 100 words. You can add the designer information. However, the designer has the right to waive his right to be cited in the register. Also for European designs, you can claim priority of an earlier application, and you can do that when filing or within a deadline of 1 month. You can also claim a so-called exhibition priority if you have displayed your design on an exhibition, and you also can do that when filing the application or within a deadline of 1 month. And you have to indicate the name and the date of the exhibition, and also provide exhibition documents for the evidence of display, and you have a deadline of 3 months. And I'm gonna hand back to Mark and Tania now.
Thank you, Simone. So just a couple of final points from us on what we have described and set out today. So a couple of take-home points. We refer to them as practical tips. I guess just guidance generally on how to make the most of the situation that we find ourselves in and the differences between the UK and the EU system, and particularly with Brexit in mind, how you should be approaching the EU and the UK market from now on, be it national direct design and trademark filings in the UK and European Union, or designations made via the Madrid Protocol, for example. We may be more in tune with doing one of those routes to the UK and the EU than the other, but the same logic applies. So the first thing I would say, as Tania mentioned, that shapes can be protected as both designs and trademarks in the UK and EU. It's one thing that we often advise on and get asked about, and it's one thing bearing in mind that to get the best protection for your clients, if they are looking to register shapes, doing so via design and trademark protection, if possible, is a good thing to do. So bear it in mind. On the Brexit point, particularly, as we've said, from now on, dual filing and renewal is going to be needed for the EU and the UK, and that does include designations via the Madrid Protocol as well. So hopefully one of the things that you'll take away from today is that you can no longer simply rely on the European Union to cover the UK. That no longer applies from the start of this year, and hopefully that hasn't been a surprise to you, and you may have already been operating like that already. But that's really the headline point that shouldn't be missed. So please do bear that in mind. And one of the things as well that we're finding is that it will be important to monitor the comparable UK trademark applications that are being filed if you have any instances of ongoing opposition proceedings at the EU IPO against an EU trademark application, because what you could find yourself in the situation of is that you continue with the EU opposition only, but in the meantime, before the 30 September deadline this year, a UK comparable application is filed, goes unnoticed by you, that achieves registration in the UK, then you have to perhaps validate that registration. Just a much more streamlined way to do it by opposing at the outset. So if you have that situation, to monitor it. What happened there? And the other thing on deadlines, I've said it many times, probably sick of hearing it already, but the 30 September 2021 deadline is one that you should take note of. Those pending applications need to be filed by then if you want to keep the same details as the parent EU application or designation. So be aware that those comparable applications should be filed by then. And on the license and ownership changes point that I made before, January 1 is a deadline there, so just bear that in mind if that applies to any cases that you handle. And finally, as I said at the very start, just to come full circle on this, European patents aren't affected by Brexit. So if you wanted to find out more about patents and the effect of Brexit on them, very short answer, nothing changes. And that also applies to how we can assist you in the UK and Europe. As we've said before, we've got offices in the UK, France, and Germany. We're a European firm. We can act at the EU IPO, European Patent Office, and the national registers in the UK, France, and Germany as well. So that means we are a truly European firm, and nothing changes insofar as how we can act for you, despite Brexit. And that brings us to the end of the webinar. We were welcoming questions in the chat, and I'm going to hand you back to Tania now to moderate the question session, which I'll do in a second. On our slide here, you have our contact details. So if you do have any questions that come to mind after today, or something you wish you'd asked at the time, or something that comes up in your day-to-day practice, do just get in contact and we can give you a steer. But thanks for taking the time to attend today, and I hope this has been of some use to help you navigate through the murky waters of Brexit. Thank you very much.
Thank you, Mark.